Hello, everybody. Welcome to this, our latest employment law webinar. I'm Matthew Cole and this is Vanessa Bell. We're both partners in the employment team at Prittis. What we're going to be talking about today is that old cliche, your employees are your greatest asset, but also your greatest liability. The original title for this was Vicarious Liability. But we thought that was just perhaps a bit too technical, legal, so instead we changed it for something we could have an exclamation mark to. What we really want to talk about today is relatively briefly four cases from I think the last 2 years, which, and actually some of the cases you may be familiar with, which look at what happens or what, those circumstances when an employer can be liable for the acts of others, in particular their employees. And this is what vicarious liability is. It's where you as an organisation are liable for the wrongful acts of others. And up until the early 2000s, it was very much a case that the rules were quite restrictive, and there had to be a real degree of control, and that's because it came from the old law of master and servant, which is the law that predated employment law. Quote here from one of the early cases, an 1867 case, Barwick and English Joint Stock Bank, which really sets out the principle. The general rule is that the master is answerable for every wrong of the servant or agent as is committed in the course of the service, and for the master's benefit. That no express command or proclivity at the master is approved. Now, as I said, this was very, very restrictive. There needed to be an employment relationship or an agency relationship, and secondly, it had to be a situation where there was a real degree of control by the master over the servant. But what we've seen really in recent years is a number of cases which has gone much further to expand this concept of vicarious liability and really to take it outside of that very technical control of the relationship, to introduce a much broader relationship, but also, I think it'd be fair to say, a much more uncertain relationship as to when the employer, we'll go back to 21st century language now, the employer is liable for the acts of employees and others. So what we thought we'd do is really talk through four of those recent cases, just to give you an idea of how the law is developing. Some of them you may be aware of already, but we can just perhaps talk around the kind of circumstances that come up, and then we'll touch briefly at the end on what you might do to try to give yourself a degree of protection as an employer. We'll try not to make that bit too depressing, because in some respects there's not a lot, is there? No. So anyway, that's what we're going to talk through. As I said, started off very much about control. As we see from this slide, what we have started to focus on instead is really two questions. Is there a relationship between the wrongdoer and the employer which is capable of giving rise to vicarious liability? And what we'll see is that the courts look at this in terms of justice and equity. Is it appropriate that the employer is liable? And secondly, is that connection sufficient? What is lacking there, I think, is the issue of control, and whether or not it could be said to be an act committed during the course of the employee's duties. That really has changed, hasn't it? So anyway, that's what we're going to talk about. I'm going to pass over to Vanessa, who's going to look at the first case. No, I'm not. I'm going to look at the kind of situations where vicarious liability actually comes up. So first of all, and the classic one is personal injury. When the employer is responsible for the wrongful act of an employee that has led to an injury. So, you know, if it's the employee of the employer who has not properly secured the manhole cover and a member of the public falls into it, then the employer is going to be liable. That's the sort of the classic thing. Secondly, discrimination and harassment. You can look at this in terms of protection from harassment act, but also in terms of the Equality Act and liability under the Equality Act. Slightly different test there, perhaps, to the statutory test. The statutory test is slightly different to the master and servant test, but essentially it's the same thing. when are you as an employer held to be liable? Thirdly, very significantly, liability in terms of data protection. We'll look at the Morrison's case. What happens when you have a rogue employee who deliberately seeks to harm, to breach data protection laws? And finally, assaults and criminal activity. When can the employer be liable for those acts? And there's been a number of cases in this area as well. So they're the kind of situations where you as the employer may look at this and think, right, okay, well, this isn't us. This is someone who is working for us. Why should we be liable? We do not have anything to do with that. We employ these people, and we do our due diligence at the beginning, and then we let them get on with it. Unfortunately, there is the potential for liability there. So now, I think it's over to
Yeah, so this is just a list of the 4 cases that we're going to look at during the webinar. And then the first one that we're going to talk about has Morrison's in it, and I think they appear in a couple of the cases during this webinar. Here we go. So this one looks at the connection between the employee's position and the wrongful conduct. So it's looking at the second part of the test, which is in your slide pack. So what happened? Well, very briefly, the claimant went to the sales kiosk in a petrol station and asked Mr. Khan, who was an employee of Morrison's, if it was possible just to print some documents off of stored on his USB stick. Mr. Khan refused in a very offensive manner. He used racist language, very abusive language towards the claimant, and he asked him to leave. So the claimant went to leave. He went to go into his car, but Mr. Khan followed him. He told him never to return and subjected him to a very serious physical attack at that time. The claimant, as a result, brought an action in the county court for damages for assault and battery against Morrison's on the grounds that it was vicariously liable for the assault by the employee. The county court found that the employee had assaulted the claimant, that Mr. Khan had assaulted him, but he dismissed the claim as the court found that Morrison's wasn't vicariously liable, since the employee's actions had been purely for reasons of his own and beyond the scope of his employment. And they found that actually his job was just to essentially, serve customers. And actually the action that had taken, there was an insufficient connection between the assault and his employment. The claimant wasn't happy with this, and so he appealed. He went to the Court of Appeal, and again the Court of Appeal dismissed the appeal, and they said that, focusing on Mr. Khan's duties, he wasn't given duties which would involve the possibility of violent conduct or confrontation taking place. And again, they found that there just wasn't that connection, and they weren't going to make the employer liable. So the claimant persisted, and he appealed to the Supreme Court, and the Supreme Court disagreed with the previous courts, and they said that actually the test is looking at the nature of the employee's job, looking at what functions, or as we put on the slide there, what field of activities has been assigned to the employee, and then ask if there is a sufficient connection between the job and the employee's conduct to make it right as a matter of social justice for the employer to be held liable. The Supreme Court considered the test with regards to the connection, and they found that it remained a good test and it didn't need refinement in any way. However, they have observed that the test could be perhaps a little bit imprecise, and that's what we usually find in these types of cases, that of course a court's going to have to look at all the facts, all the circumstances, and draw a conclusion. So it will be fact specific. So they allowed the appeal, and they found that the job of the employee had been to attend to customers and respond to their inquiries. And they found that there'd been a series of unbroken events between responding to the claimant's initial inquiry and then following him out to the car and telling him not to respond to the employee's business, and then reinforcing that communication with the physical conduct. So therefore, they found that although it was a gross abuse of his position as an employee, there was still that sufficiently close connection. So if we just move on, again, this slide just gives you some more context and more explanation as to the reasons that the Supreme Court made the decision. There was a suggestion that actually at the point in which the employee stepped outside of or away from the counter, that broke the series of events, but actually the Supreme Court didn't really give too much attention to that, and felt that that was irrelevant, and it wasn't right to consider that he had taken off his metaphorical uniform the moment he stepped from behind the counter. They found that it was a continuous series of events. And they also considered the Mr. Khan's motive. His motive was racist, but again, they considered that was irrelevant when looking at whether the test of vicarious liability had been passed and had been met. And as I said, the Supreme Court did note that the close connection test had been repeatedly applied over the previous 13 years, and it didn't need refining. And what the claimant did try to do was try to introduce a new test of representative, what do you call it, representative capacity, i.e. would a reasonable observer consider the employee to be acting in the capacity of as a representative of the employer at the time of committing the assault. But the court found that this was hopelessly vague, and they felt, as I said, that the test that we have does the job, doesn't need refining. And they also considered whether more criteria needs to be set out as to what the criteria that is needed to meet this test, and they felt that no criteria would be too restrictive, not needed, the test remains good. And this case actually was considered at the same time as another case I'm going to talk about shortly, because this case obviously dealt with the second limb of the test, and the next case that I'll be talking about later on dealt with the first one. They put them side by side and says, you know, here's your package on vicarious liability.
So obviously, very influential Supreme Court judgment.
Yeah, of course.
Acknowledgement in this case of the vagaries of the test. Yeah. Which obviously is something we then all have to live for. And poor old Morrison's again. So this is a case that may be familiar to many of you. And again, it's heading for the Supreme Court. It's not reached there yet. It's just gone through the Court of Appeal, but may well get to the Supreme Court. This involves a data breach, and the facts now are quite well rehearsed. We had Mr. Skelton, senior auditor within the company. Now, Mr. Skelton had a grudge against Morrison's, and this grudge came about because he felt that they had unfairly disciplined him over something irrelevant. But he bore this grudge for some considerable time. He decided that his opportunity to have his revenge came about when, as part of his duties as an auditor, internal auditor, he was presented with a memory stick which contained a load of payroll data, and he was asked to send it to the company's external auditors, which he did. But he also kept a copy of it. And when he felt the time was right, he then released the copy of all that payroll data, so it was names, addresses, it was how much people had paid, I think it was bank details. He released all that onto the dark web. He then called up a couple of newspapers and said, "You'll never guess what has just happened at Morrison's," because he wanted to slam their reputation. Those newspapers, rather than printing the stories, etc., contacted Morrison's, contacted the police, and Mr. Skelton was apprehended, prosecuted, went to prison for 8 years, both under the Data Protection Act and Computer Misuse Act. So on one analysis, that's the end of the story. It wasn't the end of the story, because what then happened was that the employees, and there were several thousand of employees who were affected by the data breach, sought to find that Morrison's were liable for that breach, and therefore Morrison should compensate. Went to the High Court, and what the court found was that actually Morrison's were not directly liable. They had entrusted the data to Mr. Skelton. Mr. Skelton, at the time when the data breach was committed, was the data controller himself rather than Morrison. So he was the one who disclosed this data. So he was the data controller, so no offence there under data protection legislation. And also they found that actually, other than the fact that Mr. Skelton had the opportunity to do this, Morrison's had in place good systems of data protection. However, what the court did find was that whilst not directly liable, Morrison's were vicariously liable because of the connection between Mr. Skelton and Morrison. So effectively, they were liable for Mr. Skelton's unlawful act. They focused on a number of things when reaching this conclusion. Again, they focused on the connection between Morrison's and Mr. Skelton. He was employed by them. They also focused on the fact that there was a strong connection between Mr. Skelton and the act he had been able to commit of Morrison's, because Morrison's had given him the data which needed to be disclosed, and also that actually disseminating the data, perhaps not in this way, but certainly passing on that data, was something within the Mr. Skelton's field of activities that was actually assigned to him by Morrison's. They said there was this very, very close connection between Morrison's and Mr. Skelton and what Mr. Skelton did, which meant that Morrison should be vicariously liable. The court believed that this was a harsh decision at the time that it was making it, but it was making it based upon sound legal principles. They had some sympathy with the arguments Morrison's made, which is, well, how could we be said to be liable for this act, to be connected with it in a way which not only was it something which we had turned into quite clearly an offence of misconduct, it was not acceptable to us on any level at all, but also something there which was intended to hurt us as a business, because Mr. Skelton had done this to try to get his revenge on Morrison. So everyone saw this as unfair, but the law is the law. Went to the Court of Appeal. The Court of Appeal upheld the High Court's judgment, again finding Morrison liable, again hearing what Morrison said with regards to the fact that this was something which they had no real control over and seemed to be very unfair. The court really had very little which it felt it could say to help out Morrison's on this. But one of the interesting things it could say was about insurance, and effectively that one way in which an employer could effectively protect itself against this kind of very, very large data breach, very significant level of damage potentially, was by insuring. So the court seemed to be saying, yeah, we know that you're in a difficult position, that this is a risk you have as an organisation, and therefore you're going to have to look at other ways of dealing with it. And insurance is the obvious one, to go down. So I think what we're seeing with this is that, and I think we saw it with the other Morrison's case, frankly, is that the courts are effectively saying it's bad luck. There is this sufficiency of connection. We know they're not acts which you condone or permit, but it's bad luck.
Yeah. Reality of the situation.
Yeah. Yeah. So we're waiting for Morrison's to go for the Supreme Court to hear Morrison's appeal. And maybe there's a change in the law, but of course on the previous case, that was also Supreme Court, we seem to see a particular direction of travel with these cases.
We certainly do. So this case, as I said, was considered at the same time as the other case I talked about. But this one was the Supreme Court considering the approach to be adopted in deciding whether a relationship other than the employer-employee relationship can give rise to vicarious liability. So the facts very briefly, Mrs. Cox worked as a catering manager at the prison. She supervised a number of prisoners working in the prison kitchen. The prisoners were on prison service pay. And a bag of rice was dropped, went over to pick it up, and basically what happened is a prisoner walked past, kind of tripped over her and dropped a large heavy bag of rice onto her back, causing her injury. So she brought proceedings against the Ministry of Justice, claiming damages for personal injury on the basis that they were vicariously liable for the negligence of the prisoner. The judge in the first instance court found that the prisoner had been negligent, but dismissed the claim and held that the Ministry of Justice wasn't vicariously liable. This court focused on the question of whether the relationship between the prison service and the prisoner was akin to relationship between employer and employee, and found that it wasn't, and therefore concluded no vicarious liability. The claim is appealed, and the Court of Appeal allowed the appeal and held that the Ministry of Justice was in fact vicariously liable. And actually what it did is it looked at the work performed by the prisoners in the kitchen, and they found that it was essential to the functioning of the prison, was done on behalf of the prison service and for its benefit. And although the relationship was different from a normal employment relationship, actually, if you think the prisoners are bound to the prison in terms of their sentence, in terms of the fact that the prisoners' wages are nominal, and actually, if anything, they found that those differences make the connection stronger than that of an employment relationship, but then obviously more freedom of the contract entering it and not entering into it. So the Ministry of Justice appealed to the Supreme Court, and again, they tried to argue that the relationship between the prison service and prisoners was different. Supreme Court dismissed the appeal and agreed with the Court of Appeal. And they said that the two issues, which is the test obviously, is first, whether the relationship between the prison service and the prisoners working in the prison kitchen was one capable of giving rise to vicarious liability, and if so, whether there was a sufficient connection between that relationship and the act of the prisoner to justify vicarious liability. So how did they approach it? Well, they approached the first question in light of a case called the Christian Brothers case. And this considered similar issues. And what happened in the Christian Brothers case is that this actually extended the scope of vicarious liability beyond the employer relationship. So if we just move forward to the next slide briefly, this slide sets out the Christian Brothers findings. And what it does is that it sets out the 5 different criteria that they say that if these are met, then actually the relationship justifies vicarious liability. And we've put the criteria up there for you. And it says, the employer is more likely to have the means to compensate the victim. The tort would have been committed as a result of activity being taken by the employee on behalf of the employer. The employee's activity is likely to be part of the business activity of the employer. And the employer, by employing the employee to carry out the activity, would have created a risk of that tort, that negligence, that assault being committed by the employee. And the employee will, of course, to a greater or lesser degree, have been under the control of the employer. So the Supreme Court went back to this test. So this is the test that we need to consider when looking at the relationship between the prisoner and the prison service. And so they said that, a relationship can probably give rise to vicarious liability on the ground that it's akin to that between an employer and employee. So moving on to the next slide, they actually looked at the Christian Brothers test and they looked at the 5 criteria. And what this case is quite helpful in that it actually found that not all 5 factors got equal weight. They found that the first and the 5th elements, so the first one is the financial means and insurance, and the 5th one in terms of control, these have perhaps got less importance than the other 3. So the remaining factors, that the activity is carried out on behalf of the defendant, that it's part of the defendant's business activity, and that the risk of the tort has been created by the defendant. These were all interrelated and these were all important criteria. And they also found that payment of a wage wasn't essential when looking at this relationship. So what we're going to do is I'm just going to skip back to, sorry for jumping around, the previous slide, and this is basically the court just giving the reasons as to why they found that the test had been satisfied. So they found that the prisoners are integrated into the function of the prison, and they found that it doesn't have to be, you don't have to be commercially motivated, and the activities don't have to just benefit them, the prisoner, but also the prison service. And they made the point that actually the fact that a prisoner is required to serve part of his sentence in prison and he undertakes useful work there binds him into a closer relationship, which of course Appeal found, so a closer relationship with the prison service that would have been the case for an employee. And the only other point that I was going to just make on this case is, of course, it is an interesting case because it takes you outside of the employment relationship, and as the court has said, it focuses on the criteria set out in Christian Brothers, and this amounts to the modern theory of vicarious liability, apparently, in all cases outside of traditional employment relationship. So I think for businesses, it is an important one to note, and it obviously covers just all types of kind of working relationships or people even working on site, potentially looking at the particular circumstances.
Yeah, I think it does, and I think the case I want to look at again just brings that point about the nature of the relationship out. Obviously, not everyone has prisoners, but most businesses do have some form of independent contractor or similar. And what this case does, the Barclays case, is really focus on an independent contractor, and ability to make the organisation liable for their acts. It's one of these depressing cases, and there are many depressing cases in this area, because it involves allegations of historic sexual assault. So there are 126 claimants to this particular case. What happened was they date back to the mid-70s to the early 80s, and Barclays, when they were taking on new staff, would send staff to be given a clean bill of health. And they had a doctor in the northeast, Dr. Bates, who was providing this service. He was a GP, who was winding down his GP's practice, but did this kind of work as well as other forms of medical screening work. And what would happen was that an employee would receive an offer from Barclays. They would then be set up with an appointment for Dr. Bates to give them a clean bill of health or not, which was then used to decide whether or not they could actually start work, and also whether or not they were going to go into the life assurance scheme, etc. So most of the claimants in this case were at that time fairly young women, 16 plus, and what would happen was they would turn up for their medicals, which would take place in a room at Dr. Bates' house, which had been converted into a surgery, and he would sexually assault them. This remained hidden for some time, but it started to come out in the early part of the century, by which time Dr. Bates was actually dead. So the claim proceeded, which is along the lines of, as we've seen with other cases, whilst Dr. Bates may not be available to answer for his crimes for the damage caused, Barclays Bank is. And this was a preliminary hearing as to whether or not Barclays should be vicariously liable for the acts of Dr. Bates. So again, Dr. Bates never a direct employee of Barclays, which is the link with the prison case we just seen, but obviously not a very close degree of control. He would receive payment from Barclays, obviously, and Barclays would make the appointments, but it all took place at his own surgery and with him very much as an independent contractor. And the judge in this case applied the Christian Brothers rules very much as Vanessa has just set out. They looked at the fact that the bank had the means to meet the claims. They looked at the fact that the bank had controlled who would be appointed to carry out these medicals, and that it was Dr. Bates. That it's Dr. Bates who, it's the bank that paid Dr. Bates for the examination, and it was work that was carried out for the benefit of the bank. And effectively, he was an integral part of that recruitment activity of the bank. The bank had also been the one who directed the claimants to have the examinations. If they wanted to work at the bank, they would have to have a medical examination, and therefore, again, the court saw very much that the bank had created that particular risk. And whilst quite clearly the degree of control could be said to be very, very loose indeed, Dr. Bates is there as a medical professional, he's employed by Barclays, he's not working from Barclays premises, etc. The court in this case held that there was enough control for Barclays to be in principle liable for this. So because of that, there was such a close link between the unlawful activity and Barclays, that Barclays were therefore liable for that committed by Dr. Bates. So, on that depressing note, what do we say? What can we take from this? I suppose we can take the fact that we have seen a very conscious effort on the courts over the past few years to ensure that there is a solvent defendant, I suppose, tortfeasor, to these to the various wrongs committed, and that's an important point of policy, I think, as far as the courts have been concerned, and I think when we see that from the Supreme Court in particular, that's important. We've seen that they are very much looking at this as a matter of justice and equity. So again, they will look at whether it's right that the employer should be liable. And as Vanessa said, I think it could be seen that brings it does bring a degree of uncertainty into the mix. But it's one which as a matter of public policy, the courts are prepared to say, yeah. And then we see that actually the idea of control is much wider now as well. It used to be just employees. It can be when there is a tighter relationship, such as a prisoner, or where there's a much looser relationship, such as an independent contractor. So I suppose that begs the question: what do we do about all of that? What can we do to prepare? So looking at you, what do we do?
So create all the problems and then let them move beyond. Well, data protection is insurance, isn't there?
There is, and of course other forms of insurance for some of these. The difficulty, I suppose, in Barclays is finding an insurer who will cover this going back into the mid-70s. But we do end up with insurance being a major part of this.
Well, there's this sort of actually, I mean, looking at all those cases, you think, well, what could the employer have done differently, or the business have done differently, and actually, you always come up with, well, I'm not sure what they could have done differently. So I suppose it's like Morrison's, you're unlucky sometimes to end up with these things, but I suppose you make your own luck. You do need to train. You do need to do things to remove the risk as far as possible. And I suspect in the prison case that may have been an issue. You do need to do your due diligence. We're in a very different age to the one where Dr. Bates was able to examine patients in the way in which he was, but it's a case of choosing people carefully. Close supervision style.
As much supervision as possible. And I think also we talked a bit about insurance, but certainly in the Morrison's case, I think audit software as well would have been useful in that. You might not have been able to send it all out. There's no one answer, and there's certainly no perfect answer. But I think it's just a case of recognising that there is this wide degree of liability, and we've got to be really vigilant about it.
Absolutely.
So we hope you found that useful. Any questions, then please do get in contact with us. We'll be back next month on another subject, which we'll decide during the month.
Exactly. Soon people